question, Lord Browne of Ladyton.
My Lords, I beg leave to ask the question in my name on the order paper.
My Lords, investor-state dispute settlement mechanisms offer investors an independent means of legal redress to seek compensation following a breach of international investment agreements. The report notes that outside of the UK, investors have brought ISDS claims against climate change measures. The UK, however, has not faced a successful ISDS claim. On the 22nd of February, we announced withdrawal from the Energy Charter Treaty to avoid remaining in a treaty not aligned with our energy security and net zero ambitions.
The 7th of December, in a debate on Latin America, on the motion moved by the noble Baroness Lady Hooper, in the context of our trade deal with Colombia, my noble friend Baroness Cousins raised the issue of the inherent manifold injustices of the ISDS. In response, the noble Lord, the Minister Lord Ahmed, who responded to the debate, wrote, asserting that the ISDS is an effective means of resolving disputes, and the government is content with the standard of protection provided. So it's surprising that none of the free trade deals concluded since Brexit contain an ISDS. And the absence of one is an explicit goal of our negotiations for a UK-Canada deal. So what then is the government's view of an ISDS as a means of resolving disputes? If they've shifted their view, what's the government doing to ensure its new approach is reflected in respect of trade with Colombia?
A complicated area, and of course these treaties are bilateral, and they also help to protect the investments of UK companies investing in other overseas territories. But however, the UK's investment policy is designed to protect the UK's right to regulate the public interest, and so far we've been successful in that we haven't seen any successful claims against us.
My Lords, the UN Working Group on Business and Human Rights has said that the ISDS mechanism incentivises investor irresponsibility, and yet currently there is a case of a UK-listed company using the ISDS in Colombia in a way which undermines the fundamental interests and rights of the Wayuu indigenous people. As penholder at the UN for the Colombia peace process, what is His Majesty's government doing to discourage such activity?
Well, I thank the noble lady for her question. I obviously can't comment on cases that are currently ongoing, but we'll certainly bear her comments in mind when we consider our policy on this matter.
My Lords, with fossil fuel and mining industries already having won over $100 billion in awards and at least 175 treaty-based ISDS cases closed or pending that are directly related to environmental measures, does the Minister agree that foreign investors are using the dispute settlement process to seek exorbitant compensation from states that seek to strengthen their environmental protection? Can I ask the Minister, what actions is the government taking with partners and allies on the international stage to try and find solutions to these problems?
Well, as the noble lord is probably aware, there are discussions within the OECD at the moment about the use of these clauses, but as I say, we are responsible for the ones that we have signed and that we are recognising and arbitrating against, and we very carefully ensure that these clauses protect our right to regulate in these circumstances on energy and climate change matter, and the success of that has seen that we have seen no successful claims against the UK.
While, of course, we will hear a lot about the importance of investor confidence, it is also as important to ensure that governments, particularly of less affluent and more vulnerable nations, are able to fulfil their climate commitments. The estimate of those governments fulfilling their commitments under the Paris Agreement might be liable to pay up to $340 billion in future cases under this system. Will the Minister tell us what the government's assessment is of the impact that this system will have on limiting the increase in global temperatures to 1.5 degrees centigrade above pre-industrial levels?
Well, the noble lady is using the generality to refer to the specific in terms of ISDS clauses are very useful in a whole range of different areas. Now, obviously, I accept her point that there is some evidence of them being misused in the case of energy and climate change policies, and we will, of course, work with international partners to see how this can be mitigated, but we are very careful in terms of the ones that we agree to make sure that they preserve our right to regulate. Other countries, of course, take their own decisions.
Many developing countries are handicapped by clauses in foreign direct investment agreements, sometimes called stabilisation clauses, which forbid the hearing of disputes in local courts. As a result, local courts' lawyers are unable to develop the expertise or necessary institutional structure to combat corporate power. What steps is the government taking to ban the inclusion of such clauses in FDI agreements, at least for the UK companies?
All such agreements are different. Many of them rely on international arbitration panels that are appointed by the complainant company, by the defender company with an independent chairman. And we are very careful in how we regulate these matters, what clauses we agree to. And as I said earlier, we will work with other countries to look at their particular disputes as well.
ISDS is that it's a secret process as opposed to a multilateral judicial process, which is more transparent. Given the fact that ISDS can be used against small emerging economies, deliberately facilitated by legal firms based in the UK, what discussions has the government had with our legal community to ensure that ISDS is not just about protecting UK interests, but UK's legal community in the UK is not using this strategically against emerging economies who do not have the capacity in secret processes to defend themselves?
As I said, ISDS clauses work both ways, and they also seek to protect the interests of UK companies investing in other overseas economy. Any state that wishes to regulate against the interest has to prove that they are being transparent, that they are being fair, that they are not discriminating against foreign investors, etc. All of these criteria are used to make judgments about whether cases will proceed or not.
ISDS arrangements in the context of the CPTPP bill recently, a number of noble members expressed concern about impact on environmental standards, and the response from the government front bench was not to worry, it won't be used in this way. Now, clearly, that is not the case with Colombia. They've faced up at least 21 cases under the ISDS process, mainly from mining companies, mainly questioning the effect on the country's environmental standards. Given the pressure that Colombia is under in its transition to full democracy and peace, would that money that they inevitably have to spend on defending these cases, and in some instances paying damages, be better spent on maintaining the peace process?
I'm sure it would be, to answer the noble lord's question, but we are responsible for what clauses we agree to in the UK. We always protect our right to regulate, and we seek not to take actions that are arbitrary or discriminatory against foreign companies, but ultimately it is a question of what clauses Colombia agreed to and what the criteria they use and how it will be arbitrated. So it's a very difficult question for me to answer.
My noble friend will be aware that when we were both in the European Parliament, we used to debate the issue of ISDS. And one of the reasons that ISDS was asked for by investors was to make sure that they had confidence, particularly where there was no confidence in the local legal system. But the other side of that, of course, is that big companies were seen to get preferential treatment, being able to go to the ISDS process rather than through the legal system. Surely we have to look at the trade-offs here, and maybe one of the things maybe we could look at the impact, or my noble friend's department looked at the impact if we did not include ISDS in agreements, how much that would affect outward investment or inward investment into these countries.
I think my noble friend makes a powerful point. Of course, it works both ways. We want to protect UK companies' interests, operating sometimes in very hostile, non-democratic countries with unclear and murky legal systems. By the same token, we need billions of pounds worth of investment into the UK. We are the top European destination for inward investment to help us in our energy and climate change transition. And so it's important as well that we demonstrate that we are liberal and we are open to companies investing here in the UK. And these clauses help to deliver that, but they need to be structured in the right manner, they need to be transparent, and they need to be liberal.